Welcome everybody. People are just coming in from the waiting room. Welcome everybody to the webinar, Traffic, Parking and COVID-19 Fines. What are your payment and review options? Brought to you today by Redfern Legal Centre. My name's Alexis Goodstone. I'm the Principal Solicitor at Redfern Legal Centre, and it's our pleasure to be with you today. I would like to start by acknowledging the traditional custodians of the land on which I work and live, the Gadigal people of the Eora Nation, and pay my respects to elders past, present and future, as well as welcome any Aboriginal people present here today with us. I come to you from Maroubra, which means place of thunder in the local Aboriginal language. Just to let you know, we're videoing this webinar as well as live streaming it via Facebook. We will send you the video afterwards, along with some of our fact sheets about fines and the new COVID-19 laws. I should point out from the outset that fines resulting from breaches of the new COVID-19 laws are dealt with pretty much in the same way as all other fines in terms of appeal options and options for seeking a reduction or waiver. So we have David Hofierka, who's our Credit, Debt and Consumer Law Solicitor, and Samantha Lee, who's our Police Accountability and Administrative Law Solicitor at Redfern Legal Centre. The way it's going to be structured is that David will talk for about 20 minutes about penalty notices and court fines, what happens if you don't pay a fine, payment plans, work and development orders, which we call WDOs, the new 50% fine reduction option for people, making a write-off application, and also the advocacy hotline. And Sam will then talk for about 20 minutes about the internal review process with Revenue New South Wales, court review, a little bit about children and fines, and a little bit about the COVID-19 fines and the review by the Police Commissioner of those ones. Please put your questions in the Zoom chat and I will put them to the presenters, and please keep them brief. And remember, if you're working with clients who have fines, you can always refer them for legal advice. If they have a COVID-19 law related fine, Redfern Legal Centre has a statewide service, so you can refer them to us. And if they have a traffic or parking fine, you can refer them to their local community legal service. And you can find who is the relevant service on the Community Legal Centre New South Wales website. So without further ado, I'd like to introduce David Hofierka. Over to you, David.
Thank you, Alexis. Hi, everyone. It's a pleasure to be on this webinar with you. I will be talking about the different options people have to deal with their fines. That is, if they accept the fine, but they can't pay the fine, they might be in financial hardship or be experiencing some other disadvantage. My colleague Samantha Lee will be talking about the review process if you want to challenge the fine internally or via the court process. The four main options that I'll be talking about today are number one, dealing with a fine through a payment plan. Number two, applying for a work and development order or WDO. Number three, applying for a 50% reduction of the fine, which is the newest process or the newest option. And number four, applying for a complete write-off of the fine. But before I talk about those options, I'm going to talk about the actions that can be taken against the person if they don't pay their fine throughout the different stages of the fine process. Also, it's important to note that we're going to be talking about penalty notice fines and not court fines. It's important to distinguish between the two because not all options available to deal with penalty notice fines are available to court fines. The processes are different. However, Redfern Legal Centre has fact sheets for both court fines and penalty notice fines on its website that gives you a breakdown of the various options. So, and just briefly, so the difference between a court fine and a penalty notice fine is a court fine is issued by a court and can usually only be dealt with or taken away by a court. That might include things like court costs, a levy that's been imposed by a court, such as a victim's compensation levy, and whereas penalty notice fines, on the other hand, are usually issued by an authorised officer, such as a police officer, a council officer, a transport officer, and they include most on-the-spot fines, which are issued as penalty notices, such as parking and speeding offences, public transport offences, driving unregistered or unlicensed, and COVID fines, which fall into what I'm talking about and also what Sam is going to talk about in the next segment. So I'm going to share my screen now. So you should be able to see life cycle of a fine. And so basically what happens if you don't pay a fine? Well, the very first thing that will happen is you will receive a penalty notice. You'll receive this either on the spot by a police officer, for example, or by mail from Revenue New South Wales, which is the body that the government agency which administers fines and administers the collection process. When you receive the initial penalty notice, you'll have 21 days to pay that. But don't stress if you can't pay it by that date, because you will receive, after that, you will receive a penalty reminder notice and be given a further 28 days to pay the fine. However, if it goes over those 28 days, the fine will enter into the enforcement stage and you will receive an overdue fine notice, and $65 will be added to the fine. You will also have another 28 days to deal with the fine. And if all those time limits have passed, then enforcement action will start against you. And I'll just stop sharing my screen. Yep. So basically, what will first happen is Revenue New South Wales could take action in conjunction with RMS, Transport New South Wales, to suspend your driver's license. They could also suspend your registration. Registration. And the third thing they could do is place a business restriction against your name, meaning you cannot do any work with RMS, like renewing your license or renewing your registration. And if any of these three actions are taken, $40 will be added to your fine. And what happens if you still haven't paid the fine? Then further enforcement action can be taken by way of civil sanctions. There are 4 major civil sanctions that can be taken against you. Firstly, a property seizure order can be ordered against you, allowing a sheriff to come to your house and sell your assets or any valuable property to pay off the fine. The second thing that could happen is a garnishee order could be issued to your bank or to your employer, meaning money can be deducted from your bank account or your wages to pay for the fine. The third thing is an examination summons requiring you to come to the court and provide details about your income, assets, bank account details, so Revenue New South Wales can decide what action it might want to take against you, further action. And the fourth thing that could happen is a charge could be issued against any land that you own, preventing you from selling any real estate before you pay off the fine. If any of these, if all these options are unsuccessful, you could be taken to court and issued with a community corrections order requiring you to undertake community service to deal with the fine. And this will go on your criminal record. So the next thing I'm going to talk about are your options. what are the various options available to you if you can't pay your fine in one go? Well, the simplest way is to arrange a payment by installments or a time to pay application, which is another way of saying that. There are two ways you can do this. If you can pay the fine off in 3 months, you don't have to contact Revenue New South Wales. All you need to do is pay either $40 or 1/6 of the fine, whichever is greater, before the reminder notice due date. And once you do that, Revenue New South Wales will send you a payment plan to ensure that you pay off the fine within 3 months in fortnightly instalments. The second way is to actually call Revenue New South Wales and try to negotiate a payment plan directly. This can be done at any stage of the fine process, and except when an application to court is made to deal with the fine. And depending on the circumstances of disadvantage, it's not unusual for a payment plan to be arranged as low as $5 to $10 a fortnight, especially if a person's being assisted by an advocate, a community worker, financial counsellor. And the payment plan can also be arranged where money is deducted from someone's Centre pay automatically if they're on Centrelink. But what if the person doesn't have the financial means to pay the fine at all, or they just want other options? Well, arranging a work and development order or applying for a 50% reduction of the fine are the next best options. I note that to be eligible for a 50% reduction of the fine, Revenue New South Wales have to be satisfied that you cannot pay the fine through a payment plan within 12 months, or you're not eligible for a work and development order. So we'll talk about work and development orders next. You will qualify for a work and development order if you are experiencing any of the following. You're in financial hardship, which includes being on Centrelink or under 18. You have a mental illness, cognitive impairments, or you're dealing with alcohol or drug addiction. A WDO allows a person to work off their fines by engaging in activities through an approved WDO sponsor, such as community work, medical treatment, counselling, doing an educational course, volunteering opportunities, financial counselling. And there are different payment rates that work off your fine through a WDO, which are on the Revenue New South Wales website, and I will share my screen again to show you that. So those are the payment rates. And so, for example, if you're doing community work or seeing a financial counsellor or education, then your fine can be worked off at $30 to $50 an hour. However, if a person receives treatment through a doctor or through another health practitioner, such as a mental health counsellor or a psychologist, your fine can be reduced by up to $1,000 a month. The good thing is that it isn't required that you complete a number of hours through those health providers. You just got to engage with the treatment, and you will be eligible to have your fine reduced by $1,000 a month. And it might only take 1 or 2 sessions a month to have that benefit. And finally, Revenue New South Wales and Legal Aid New South Wales have special WDO hotlines that can help link people up to suitable WDO providers. And so I'll just stop sharing my screen again. Okay, I'm back. So up next, who would qualify for a 50% reduction of their fine? First up, this option only became available on the 1st of July 2020. So fines that have penalty reminder notice due date after the 1st of July aren't eligible for a 50% reduction. And if a fine has passed, progressed to the enforcement stage of the fine, then you're not eligible. Anyone who receives a government benefit, such as Centrelink, is eligible for a reduction, but have to satisfy Revenue New South Wales that they are in financial hardship and they can't deal with a fine through a payment plan or WDO. So, for example, you would be eligible for a 50% reduction if you had multiple fines, which would mean a payment plan would be pushed out to be more than 12 months, or you're too unwell to comply with the WDO, or you're already seeking treatment from health practitioners that aren't WDO sponsors. In addition, a 50% reduction will not apply in the following circumstances. It doesn't apply to court fines. It doesn't apply to voting or jury duty fines. And it doesn't apply to fines that are considered significant offences. These offences are listed on the Revenue New South Wales website, and I'll just show you that list. So there's that list. The first set of dot points are some offences that would be eligible for a 50% reduction, and the second list are offences that typically wouldn't be, such as speeding offences, drug and alcohol driving offences, red light offences, seatbelt, mobile phone driving offences, criminal offences, and COVID fines. And another thing to note is that a reduction will not give you back demerit points, and they will also, a reduction cannot be applied for repeat fines, repeat offences. For example, if you've been charged with multiple parking offences, then it is unlikely that you'll be given a 50% reduction for the latest parking offence. However, the restriction on repeat offences will not apply if you can show that mental health or homelessness contributed to the repeat offending. However, we still encourage people to apply for a 50% reduction, even if they've been given a significant offence or a repeat offence fine, because Revenue New South Wales have advised that they will look at each case on a case-by-case basis and have the discretion to apply the reduction depending on the circumstances of disadvantage, if there's exceptional circumstances. And to apply for 50% reduction, it's as simple as calling Revenue New South Wales. You'll have to provide evidence of your Centrelink or government benefit, such as providing your CRN number. However, Revenue New South Wales do have the option to ask for further documents to verify your financial hardship, such as pay slips or bank statements. And if you've been approved for a 50% reduction, you can pay the remainder of the fine. You can arrange to pay it through a payment plan as long as it's paid within 12 months.
David, somebody's asked whether if you get a 50% reduction, you can do the balance with a WDO.
I can't see why you can't, especially if you've secured that 50% reduction. Obviously, to get that 50% reduction, Revenue New South Wales would have had to be convinced that you couldn't do a WDO. However, if you somehow became able to do a WDO for that other 50%, once the reduction is applied, then you could give it a go. I can't see how you couldn't, so you could try. And so finally, if you find yourself overwhelmed with multiple fines or can't deal with your fine through a WDO 50% reduction or a payment plan, you might have thousands of dollars worth of fines. And if you can provide evidence of exceptional circumstances of disadvantage, then a write-off might be your best and last option. If successful, your write-off, your fines will be written off for 5 years. And as long as you haven't incurred more fines within those 5 years, or your financial circumstances haven't improved, the fines will be written off indefinitely. You can apply to Revenue New South Wales to yourself to apply for a write-off, just providing the supporting documents they require, including a statement of financial position, detailing your income and assets. And however, if you do have thousands of dollars worth of fine, and it would be a good idea to get advice from a community legal centre who might be able to assist, because it can be a long process. The Hardship Review Board is an independent government body to Revenue New South Wales. They review unfavourable decisions regarding WDO's write-offs payment plans, if you've been, say, rejected for one of those. However, they don't review 50% reductions. Reviews and appeals of decisions regarding 50% reductions are made directly internally to Revenue New South Wales. And the last thing I'm going to talk about is the Revenue New South Wales Advocates Hotline. So many people obviously can't advocate for themselves. They, because of their vulnerability and disadvantage. That's why lawyers, financial counsellors, community workers, health workers, social workers have access to a specialist hotline to arrange the kind of things that I've talked about today directly with Revenue New South Wales on behalf of a client, and usually can get better outcomes for the client than if the client rang up themselves. If you haven't already registered as an advocate, it's a simple one-page form on the Revenue New South Wales website. And once you are registered as an advocate, you can help the client with other things, such as obtaining a client statement summary, which is a detailed list of all the enforced fines a client has. And you can also negotiate holds on fines, like 30-day holds or more on enforcement action, to give the person more time to deal with their fine. And you can also arrange for RMS restrictions to be lifted, so someone can get their license again, registration, so they can drive again. So those are a number of things you could assist with. And that's all from me.
You're on mute, Alexis.
The old mute problem. Thank you very much, David. One person has asked, let me have a look here. So that there was a question about the WDO and the 50% reduction. Someone's asked whether the WDO activities are funded, or are they at the expense of the individual?
No, most are free, like free financial counselling. A lot of it depends on, all service providers need to be registered as WDO sponsors. A lot of them are free. However, for example, if you need to see, a lot of medical services might be Medicare. If you need to see a psychologist, for example, and they do charge, you could apply for a mental health care plan through your GP, and which will give you a Medicare rebate. So yeah, look, some do charge, some say health providers, but most are free. Especially the volunteering work. You could do an educational course, that would be covered by the government. Most are free.
Great, thank you. There is another series of questions, but I think they're probably better directed to Sam, because they relate to the nature of an offence or challenging an offence. So I might hold those over and introduce Sam, who's going to talk about, as opposed to David, who was focusing on reducing fines and getting waivers on the basis of hardship and financial situation. Sam's focus is going to be more on appealing a fine because you say don't agree that you should have been, that you've committed an offence in the first place. So I will introduce you now to Sam.
Good morning, and thanks for joining us today and giving us your time. I would also like to acknowledge the Gadigal people of the Eora Nation and pay my respects to elders past, present and future. I just want to start off by giving a few facts around fines. There's over 7,000 offences in approximately 100 legislative instruments which you can get a penalty or fine for in New South Wales. There's a 2.8 million penalty notices issued each year in New South Wales, which just tells you how widespread fines are. I'll put up my hand that I have received a fine. And usually when you receive a fine, you tend to get a bit defensive and think that you don't deserve it. So I'm just going to speak about mainly the internal review process and also looking at the court option in regards to fines. I'm also going to talk about a little bit about review of COVID-19 fines, which is a bit of the hot topic at the moment, and just a little bit about fines and children. So let's just initially look at internal review and fines. So when I say internal review, what I'm talking about is a government organisation actually reviewing your fine. In this circumstance, we're talking about Revenue New South Wales, but each state and territory will have their own review body. Now, Revenue New South Wales has an online portal where you can seek a review through their online portal. And what that portal does is it then says whether they will review your fine, actually Revenue New South Wales, or what they can actually do is send your review to the actual department that issued you the fine. For example, if it was police, then they can also issue your fine to police to be reviewed. So the big question is, why would you seek a review or contest a fine? Now, I hope you get out of this seminar is that sometimes it's not worthwhile reviewing any fine. You do have to think about the fine that you received and why you did receive it. But one major point I put out there is don't put your head in the sand in regards to fines. You really need to get onto them quickly, as David has pointed out. Otherwise, the situation can get a lot worse. So try and deal with fines as quickly as possible, even seeking a review as soon as you can. So why would you seek a review of a fine? One reason is that a mistake in issuing the notice. For example, it wasn't your car, or it wasn't registered in your name, or you weren't the person that was driving the vehicle. Another reason would be that the penalty notice was wrongly issued. Now, when I say wrongly issued, when you receive a penalty notice, the notice must be given because what we call in the law is that the offence has met all the elements of the offence. For example, with a parking fine, that you were parking in an area that had a no standing or no parking area for that time period. Now, if that's not the case, for example, the sign, you were given a ticket, but you were actually in an area that wasn't signed, then that could be a mistake in regards to the issuing of the fine, and it was wrongly issued under the law. As I mentioned before, you were not the person that committed the offence, or as David has also looked at, is that there are exceptional circumstances. For example, there are financial hardship reasons, there are health or medical reasons. For example, we had a recent matter where a man, he was quite elderly, he had quite serious medical issues going on, and we sought an internal review in regards to his matter. Big issues are also if someone has a mental health issue or cognitive impairment, then those issues that you would try and seek an internal review for. In regards to traffic fines, they are quite difficult to seek a successful review, even in the courts. But one thing you probably need to consider is what your traffic record is like. So if you've received, say, for example, 2 other speeding fines in the last 6 months, then your chance of actually getting a successful review, even in the court, is probably minimal. But if you've been driving, for example, 10 years and this is your first fine, then your chances of success is much higher and could be likely to succeed. So when must a reviewing agency withdraw a fine? I think it's really important to highlight here is that the review agencies don't operate in a vacuum, that they do need to refer to legislation. And in this case, they need to refer to the Fines Act, which does direct them in regards to what fines they must withdraw. Section 24E of the Fines Act clearly states that there are some fines that they must, it does say must withdraw. And those are fines that are issued contrary to law. As I said, that they may be missing the elements of the offence. Those fines that where there is a mistake of identity, they should have regard to exceptional circumstances, such as even homelessness, that they must, says, review or withdraw those fines if you can prove that the action did occur because the person did not understand the offence, or that their control of their conduct was beyond their control. So if you can prove those things, then they must withdraw the fine. Another issue is they must look at the possibility that a caution should have been issued rather than a penalty notice. And I will talk a little bit more about that as I get a bit further on in this talk. So I'll just quickly though refer to time limits, which is always important when you're looking at a review of a fine internally or review via the court. So I'll just share this slide with you about time limits. Okay, I hope everyone can see that. We will look at sharing these slides with you rather than you having to note everything down. But really important in terms of internal review is making sure you're keeping up with the actual time frames. So if you look at this slide, if there's no payment made, then the due date for payment, you can seek a internal review by the due date for payment on the penalty reminder notice. So the penalty reminder notice, I refer back to David's slides that there are several penalty notices that you can receive. So this isn't the first penalty notice, this is the second penalty, which is the penalty reminder notice. If you paid in full and there is no reminder notice, then you can seek a review within 60 days from the date that the penalty notice was served. So the penalty notice is the original notice that you received. It gets quite confusing. So it takes, even I need to go over these time frames about 10 times before they get into my head. So don't worry if you're confused. As I said, we'll send around these slides so you have that actually in paper. Okay, I'm going to stop sharing my slide now. So that's the time limit. So what evidence do you need to seek an internal review? I think it's really important to note here that it's best if you have evidence, if you have something in writing to attach to your review, even if it's just a letter from a community worker. I know there's probably a number of community workers who have joined the session today. You can play an important role in trying to seek an internal review for clients by providing a letter of support or confirming what the client is actually saying to you. For example, that they do have minimal needs to pay the fine, that they have health issues going on. If you can put that in just a one-page letter, don't make it overly wordy. A lot of these people looking at the reviews don't have a lot of time. make it very succinct and just one page. You can attach a copy of the tickets to the review. Any police reports is good. As I said, any medical evidence, a letter from a doctor can also be very important. If you're, for example, you were fined for parking in a no parking area, but your car had broken down, you can send in proof of the repairs that were made to the car. As I said, a letter from a social worker, a doctor, a community worker from the Salvation Army, we've sometimes done. A welfare group can also be really beneficial to someone trying to seek a review for a fine. Can you submit a review on behalf of someone else? Yes, you can, but you do need to attach a letter of authority to that review lodgement. But as a community worker or for example, a guardian, you can submit a review on someone else's behalf. So what does the review agency consider? Once they've received your application, what they're really looking at, a major thing is, did the offence pose a serious safety risk to the community? So the review agency, in terms of speeding fines, you're not likely to be successful. They have a little booklet which Alexis will send out a link to. There's a number of links I'm going to share with you. There is a booklet that the review agency looks at, and for offences under 20 kilometres an hour, then they will consider a speeding fine. But if it's over 20 kilometres an hour, then they won't be looking at that for a review. So I really emphasise that it's important to look at this booklet and see what matters you can seek reviews for or are likely to succeed. Another thing they'll look at is, does the person qualify for a caution? I'll get onto that a little bit more. Does the person have a good driving record? A lot of people put in for reviews, but as I said, their driving record is quite poor. You really do need a clear record for 10-year period, which is a long time. I know there's probably not many of us around that have that clear record. But unfortunately, that is the criteria that they're looking at. They're also looking at, as I said, safety issues. If it's in a school zone, a speeding in a school zone, then they consider that a very serious safety issue, and it's unlikely that you would receive a successful review in that case. If you have a good medical emergency reason, then they will consider that. For example, you're on the way to the hospital for a medical emergency. They'll also looking at whether your car had broken down or whether it was stolen by someone else. And also, as I said, if you did not understand or were not able to control your actions, for example, if someone's going through a psychotic episode, there was some cognitive impairment issues going on, then they will consider those issues. Here's some issues that they will not consider. So if you have received a fine, if you're putting in a review in saying that you only stopped for a short period of time, that's not going to get you across the line. I know a lot of us think that it didn't, the offence happened very quickly, but that's not a reason to seek a successful review. That you did not see the sign, that's not going to get you over the line as well. As I said, that you were not there for long. Mobile phone offences, they don't like them. They see them as a serious safety issue, and they won't be considering a successful review in regards to a mobile phone issue. You can't blame your GPS. That's another thing that they look at. It's not a reasonable excuse, and it won't get you over the line. So as I said, really go have a look at the guidelines that Revenue New South Wales consider in regards to reviewing a fine before you submit a review application. I'll quickly now turn to the caution guidelines under the Fines Act. So a really important issue to consider when you received a fine or a client of yours received a fine is should they have been given a caution rather than a penalty notice? There are actual obligations on people that issue fines to consider whether a caution is the option, and that they should not give a fine if a caution is an option. So under the Section 19A of the Fines Act, it does actually state that a caution may be given if an officer believes that the offence did not involve a risk to public safety, there was no damage to property or significant impact on a member of the public, the person is homeless, they have a mental illness or intellectual disability, they're a child. A child is a really important issue. If you're acting for a child, then it's really worth seeking a review for a matter. They're in poor health. The offending behaviour is at the lower end of the seriousness scale. The person did not knowingly or deliberately commit the offence. They were cooperative and it is otherwise reasonable in all the circumstances of the case to give the person a caution. So you can refer to what's called the caution guidelines under the Fines Act, particularly Section 19A, if you're seeking an internal review or even going to the courts, and there will be a link to that. So you'll then be notified of your outcome of your review within 42 days of receipt of the application. I point out here that you don't have to seek an internal review first. You actually can go to the courts first if you prefer, and you can just lodge immediately with the court to seek your review. I'm going to quickly now move on to the court, going to court. So why would you take your matter to court? You don't believe you broke the law, you want a more lenient penalty, and you just can't afford to pay. I have found sometimes taking matters to court that you can receive leniency and sometimes is a better option than seeking an internal review. I just quickly go to the timeframes in terms of an internal, sorry, going to the court now, just share that with you. Okay, so going to court, no payment or part paid no later than the due date of the first penalty reminder notice. If you paid in full, you can still go to court. It is 90 days from the date of the penalty notice was received. If you've applied for internal review and not successful, then you have 28 days from being notified of the outcome of the review. Again, those slides will be shared, so you don't have to take it all down now. Quickly, what are the dangers of going to court? Costs. Costs are a big issue to consider. I'll quickly have a look at that. Another important issue is what we call, some offences are strict liability offences, so no need to prove intent. A really good example of a strict liability offence is a speeding offence. With a speeding offence, there's no requirement on police to prove intent or that the person knew he was driving beyond the speed limit. All they have to prove is that the radar device says that they were going over the speed limit. And people get quite agitated when they get a speeding fine, but they're very difficult offences to take to court. Okay, so what are the other issues to consider taking it to court is that it's very time consuming. You could have 1 to 2 to 3 days in court that you have to attend. The court can impose a higher penalty unit than what you got at the original offence for the penalty notice. It can be quite emotional and there's no guarantee of a good outcome. So you do need to consider why you're going to take a matter to court. I will quickly move on to the actual cost. Okay, so you've got a court. If you're unsuccessful at court, you have to pay what's called a court cost levy. which is $85 for a summary offence. And then and that's per penalty notice, so per offence. And then there's also a victim's levy, which is $83 for a summary offence. You could also pay witness expenses, prosecution costs, compensation. So you do have to consider court costs. So what matters have most likelihood of success in court? If you've got a good traffic record, then yes, they've got a higher chance of success in the court. Again, when I say good traffic record, it needs to be something at least 5 to 10 years. That's for the court itself. There needs to be clear evidence that you did not break the law. Difficult for the prosecution to prove their case. So you need to look at what we call the elements of the offence. There are extenuating circumstances such as financial circumstances. And another option to taking it to court is that you are willing to plead guilty, but what we call in the law is you have a reasonable excuse. So some courts are probably a bit more lenient in terms of trying to reduce the fine rather than Revenue New South Wales, because they do get to hear all of your circumstances and why you committed the offence. And sometimes I've found that the court can be a bit more lenient in terms of reducing the fine rather than dismissing the fine, that they may reduce the fine.
Sam, somebody's asked, if you take the matter to court, can you then seek a further review after that if you get a negative decision confirming the fine?
No. So if I imagine that question means, can I then take it to Revenue New South Wales after that?
Yeah.
Well, sorry, you can't take it, but you can. The court process has its own path. So if you've gone through the courts and you've received what we call a sentence, which is a fine, then you can seek not a review, but a leniency of that fine through the court system. But that's a little bit more complicated, another conversation, and we do address that in our fact sheets, which should be sent around as well.
And Sam, would you recommend that people obtain legal advice before going to court?
Definitely, I would tell people to seek legal advice, because the court system can be quite overwhelming. And as I said, your offence may be a strict liability offence, and your chances of success may be minimal. So it's really good to check that out first before going to court and having to put in all that time, effort, and possibly money. I don't have much time, but I want to just touch, if I can, Alexis, on COVID-19 fines. These are, the hot topic, I guess, at the moment. A number have been issued in New South Wales. So why would you seek a review of a COVID-19 fine? The reason that is being put forward why you seek a review of a COVID-19 fine is that the law was developed in haste, and there is identified issues in drafting of that legislation. So lawyers in particular are wanting to test some of these cases, but again, you need to consider the actual risks of taking matters to court, as just mentioned. There's lots of questions around the interpretation of the law, so there's probably more leeway for the courts to consider this law and to possibly find in the favour of the person who is seeking a review. Another reason might be is that you did not pose any threat to public safety. For example, you were issued a fine and you were in your car. I think that would probably be a good issue to take forward if you can afford to do that. Also, that you had a reasonable excuse to leave your house, and when you left your house, you were issued a fine by police. We've also found that police may not be adhering to what we call legal thresholds, and that a lot of these fines may have been issued not according to law. But again, you need to consider all the pros and cons about taking your matter to court. But one last slide I'll share with you, which probably sums up where we're at in terms of COVID-19 fines, is this man. Anyone know who that is? Okay, so that's the Minister, Don Harwin, and he was issued with a COVID-19 fine. Now, he actually was issued a fine because he moved from his residence in Sydney to a place at Central Coast. He was issued an on-the-spot $1,000 fine for leaving his place in Sydney with no reasonable excuse. He contested that fine in the court and said it was issued unlawfully. The fine actually was before the court only recently. His fine was dismissed on hearing, and the fine was withdrawn. The public prosecution said that the evidence against Mr. Harwin was unable to establish that he left his place of residence without a reasonable excuse, as provided by the public health order, and that the order did not restrict a person to a single place of residence. So that probably does give us maybe a little bit of hope of testing some of these COVID fines in the courts, although his matter is kind of confined to the fact that he moved from one house to another. But I think it does indicate that maybe some of these matters should be tested in the court, and the courts may withdraw or dismiss some of the COVID-19 fines. Thank you.
Sam, somebody has asked whether if there are, you mentioned that if you didn't see a sign, that's not going to be a good enough excuse to get out of a fine. If there are several confusing parking signs, would that be a basis for seeking a review?
I know what you mean. I've got out of my car and looked at all of these signs, trying to make sense of them all. It doesn't neatly fall into a reason to seek a review. They do put on people that they must look at the signs and take time to understand whether they can park there. So I wouldn't say it fits neatly into a successful review case. So I would try it, but I wouldn't put it into the highly successful basket.
And given that most people seeking review will be doing so with revenue rather than going to court, how do you actually do that? What are the ways you can do that? And how much information do you need to provide them, and what kind of evidence? Like, is it just a sentence or two, or do you need pages of submissions, and what kind of evidence would you need to submit?
Yeah, so you go to Revenue New South Wales website and click on internal review, or sometimes it just says review, I can't remember exactly, and they'll take you to an online portal. So you can do it online, but you also can still do it via just the old-fashioned letter to them. They have a mail address. As I said, make your submission succinct and as minimal paper trail as possible. Only include the evidence necessary. So include a copy of the penalty notice, which they should have anyway, but it's good to attach it. Include a letter from, say, a doctor or social worker. If you've got your car fixed, get a receipt, attach a copy of the receipt of the car fixed, or a photo. For example, if you parked, you believe, in a parking area, take a photo of where you parked. That type of evidence is what you need. Don't overburden them, because they'll look at your submission and just say, oh, it's just too much to go through. Make it as easy for them as possible.
Somebody else has asked about the COVID fines. So if police are asking you why you're out and about and you think that they're trying to analyse whether you've breached one of the COVID-19 related laws, so that the question's raising issues around kind of answering questions versus maintaining a right to silence, and how to approach that.
Yeah, it's a good question, and one that we've had a fair bit since the COVID fines came into play. I need to point out that at this very moment, you don't need a reasonable excuse to leave your house. that was in place in the early days of the pandemic in March and through a time period then, but you no longer need a reasonable excuse to leave your house. When police approach you, the legal thresholds haven't changed, so they still need to form a suspicion that you've committed an offence. Just because you're out and about does not mean you are committing an offence. You still have a right to silence, so you don't have to answer police questions. We always advise people to be cooperative. You can give them your name. You don't need to provide a formal ID. It's not required. The onus is on police to prove that you are committing an offence. So you can say your name. If you think it helps, you can tell them what you're doing. Advice is to say as minimal as possible, but be cooperative.
And somebody else has asked, do police need to give a warning prior to giving a COVID-19 fine? So someone has a client who was 16 years old at McDonald's getting something to eat with friends and was issued a fine on the spot, presumably without a warning.
Yes, police should be giving people warnings that they are considering issuing a fine. Again, if it's a young person though, they should be turning their minds to the cautioning guidelines. I think there's big questions around issuing particularly young people with fines. They should be considering other options. And again, just because they're out in the street doesn't mean they are committing an offence. An officer should also give the young person their name, the place where they work, and the actual reasons for stopping them in the first place.
So perhaps worth referring that person to a community legal centre and seeking a review on that one.
Yes, definitely.
Okay, well.
If I just point out here that at Redfern Legal Centre, we do have an advice service for people that have been issued COVID-19 fines. You can book in for a free advice session in regards to just COVID-19 fines in particular.
Yes. So that's a statewide service in relation to COVID-19 fines. And as I mentioned at the beginning, if you have clients that have other fines, traffic and parking fines, then you can certainly refer them to their local community legal centre, and you can find who that relevant centre is on the CLC New South Wales website. Well, thank you very much, everyone, for joining us. I hope you've learned something useful about fines and that you are armed better to consider whether to challenge your own fines or seek waivers or reductions, and or to refer your clients or to assist your clients directly to consider all of their options, of which there are many. As I said, we will send you the video recording and the slides afterwards. And thank you very much for coming along.